Hello again. In this module, we're going to talk about two more aspects of contracts. One of the things that is a big factor in a contract is in order for it to be enforceable, remember that's our big thing with contracts, it has to have a meeting of the minds in a real voluntary way. So it might be that somebody agrees to something, but they don't really understand what they're agreeing to, or there's something that isn't as they assumed. And I know assumed is one of those words you got to watch out, but the idea is that if you think of it this way, if it makes it simpler, somebody took advantage of them or tricked them. And so now that this contract is being enforced against that person, he or she is saying, well, wait a minute, I didn't really agree to it in the legal way. Now, by that type of agreement, we mean assent, ASSENT. That's called legal assent. So there's things that make a contract voidable, not completely void, and I'll explain why, but voidable because they lack the assent of the person who is now being held to that contract. So we're going to look at those scenarios. When you have a situation where a person takes advantage or does some other thing that now we're arguing was not fair, but we don't use the word fair. We're going much more sophisticated here. Let's say that person who is the bad doer, for simplicity's sake, then decides, well, yeah, I want to stick to that contract. We have a situation where we use a word called voidable instead of just void or invalid. And that's because the innocent person, one who was taken advantage of, has the option to get out of the contract if they could prove that that's exactly what the situation is. But the other one, the one who was the wrongdoer, does not have that option. It's best with hypotheticals, as most things in law makes it more fun too. So let me give you some examples of this. Well, one would be something we call fraud. And fraud is a very important concept in the law. It comes up again and again in different ways. Fraud could be a crime, and fraud could even be a federal crime as opposed to a state crime if it involves something that's interstate commerce, which you saw in the Constitution chapter was a part of the Commerce Clause, and that's in the Constitution. It gives federal power. So if somebody were to do something like use securities fraudulently, like insider trading, and that's the stock market, that makes it federal, it becomes a federal crime. Same thing with mail fraud, wire fraud. We can go off into that kind of fun stuff. But the point is, fraud can be a crime. But we're looking at the civil component. So we know from torts that fraud could also be a tort. Somebody could sue somebody because of the injuries that occurred from fraud. That would be the argument that makes it a tort. But in here, we're looking at it as a defense to a contract. So if somebody were to sell you land and they tell you this is a great piece of land and you check and it looks like it's a great piece of land for that price and you agree to it. But it turns out there's a nuclear power plant that's being built next door and the person who sold it to you knew that but didn't disclose it to you. And you had no other way of knowing it. We want to add those facts so that you still are diligent, do your due diligence and check. But here you just really wouldn't have known that. And so now you were in a way tricked, what we say defrauded. This person committed fraud. Now you find out there's going to be a nuclear power plant built next door, and you say, I don't want this land. You're asking to be excused from the contract. You're saying the contract is voidable because you didn't have legal assent. You didn't know all the facts, and had you known the facts, then you would not have agreed to this land purchase. And that is an example of one of these, we'll call them exceptions, but a way to get out of a contract if that were in fact what happened. But let's say oil is sprung on that land that you just purchased, and now you don't care about the nuclear power plant being built next door because you want that land. It's a great deal. And the other guy comes to you and says, oops, I accidentally forgot to tell you there's going to be a nuclear power plant built next door. Let's get out of this deal. You can decline and keep the contract. You're the innocent one, remember? And so the contract, we're not making it automatically void. So that's an example. We're going to see other examples like that. If somebody misrepresents, but they do it accidentally, they forgot to tell you a material fact. Material means important in legal words. That's similar to fraud, same result. How about if somebody takes advantage of their relationship with you? Your Uncle Fred says, I've got a great piece of land for you. And because it's your Uncle Fred, you don't do your due diligence and check the comparable land value and all that. You trust your Uncle Fred and you agree to this. Then you find out that he took advantage of your relationship. That is called, I mean, we're talking about a couple different things here, right? But that particular relationship issue is called undue influence. If that was not a relative, but perhaps it was your lawyer or somebody else in a position of trust to you, you could also try that argument again and say it's undue influence if it really was that kind of a situation that they took advantage of that special relationship. That's really what I'm looking to tell you. It's a special relationship either by being a blood relative or some other kind of legal relationship or position of trust that the person has to you. The other last that I'm going to mention as an example, and you'll see more, would be duress. So duress is if somebody forces you into a contract. They hold up a gun to your head and say, sign this check over to me. And you would argue very successfully that afterwards, when you're trying to stop payment on the check or whatever, you can imagine your scenario, you would argue, well, they didn't have your true voluntary cooperation in this contract. They didn't have legal assent. So that's where we're going with that, and you'll see more of it. And the last thing that we're going to do in this particular module is the big rule that I told you, the exception to the rule, which is when is a contract required to be in writing. We call that the Statute of Frauds. You're going to read about it. I want to give you a little more detail. I do remember the first time I saw that when I was in law school, and I thought maybe it was about fraud. And gee, this is where somebody committed fraud, like I just described to you, fraud. And that isn't what it is. It's called the Statute of Frauds. I'd like to think as a trick to help it be easier to remember that maybe these are situations where if we didn't require the contract in writing, somebody might have been subject to fraud. Somebody could have taken advantage of somebody else. So we thought, let's just protect everybody and make a writing rule in these special circumstances. It's called the Statute of Frauds. Every state has one, and some of things are a little different state to state and what they list as requirements, but I'll give you the general ones that tend to go across all states so that you'll be kind of set for knowing this, and you'll read about it more in the module. Things like a prenuptial agreement, it's better off to put that in writing. And actually, we're going to require it in writing because we don't want to deal with the situation at the end if really it's the end of the marriage and things are going south. And now people are saying, well, she said this, he said this. We just say it's got to be in writing to be enforceable. Good example. There's other things too. So if you have goods that are over, remember the number we used? You might not have remembered it, the UCC, goods that are over $500, that special amount, then we're going to say, it's a lot of money put in writing. You may say to me, hold on, $500 is not a lot of money. And that's an excellent point if you thought that, because they're talking about raising it to $5,000. But again, it would have to go through every state that decides to accept it because it's not a federal law. It's actually a state law that each state decides whether to adopt the UCC or any changes to it. So it hasn't changed yet. It might change in the future, but for now, it's still $500. And at the time when it was made many years ago, even before I was in law school, we thought, oh yeah, that's kind of a lot of money. Let's make sure it's in writing to protect everybody. So hopefully that helps you remember it. There are other situations too. Interest in land. This is why your lease has to be in writing. And if it was a land sale, someone is purchasing a house, that contract has to be in writing. So any kind of interest in land, whether it's to use it temporarily, like in a lease, or it's some kind of relationship towards the land, like an easement, a right of way to walk across the land or the property, we require those things to be in writing. I think it makes sense, when you go to check the title to see who's owned it and to make sure it's good and clear title, everything's in writing and it's all set in the town hall, in the land records, and it just protects everybody. Another example is if you have a secondary loan, and I say a secondary loan, some people call that a collateral promise. Your Uncle Fred says, okay, I'll be the backup on your contract for your loan in this bank. And they don't want to give it to you, the college student, the bank. And so they accept this with Uncle Fred as the backup promise. We call that the collateral promise. And that promise, that contract has to be in writing, even though technically your contract with the bank does not. So these are ways we protect people so that that no good uncle doesn't turn around and say, I wouldn't have done that for my nephew. And if it was in oral, right, out loud, verbal, but out loud, oral, then it might have been hard to prove. And we just don't want to set that situation up. We say, okay, it has to be in writing. So these are, if you think of it, and there'll be a couple other examples you'll see, like if it's a contract that's beyond a year before you're going to perform it, you need to put that in writing. If it was a contract for next month, you don't have to put in writing. As time goes on, it might be harder to prove or harder to remember. And again, these are all examples where we're trying to protect the parties. So you'll see that it does make sense. Even the exceptions make sense. And even the exceptions have exceptions because sometimes the contract should have been in writing and it wasn't in writing. And yet we're going to call it enforceable because they could prove it in some other way. So I like to think it's pretty flexible. You'll see that. I'm not going to go into all details of that. And actually, the last thing I wanted to tell you that's somewhat related to that is the idea that we really are, because we're looking at it flexibly, we're looking at it in terms of, I wanted to say that if it's required to be in writing, and you might say that sounds really formal, look at what the writing requirement is. It doesn't have to be required to be in printed form with big letters in a certain kind of language, legalese, like you might call it. No, it could actually be even handwritten. And as long as it's signed by the person who's now being bound to the contract, it's considered to meet the writing requirement if there was a writing requirement. So it could even be written on a cocktail napkin as long as it's signed by that person. So even the formality of contracts isn't as formal as you might imagine. I'll leave you with that note for now. Go and read through it and the hypotheticals and have some, I like to think, fun with contracts.